Well, we sort of made an application this morning. We supplied with all the statements made by Saiful to the police in the course of this investigation. Now we feel that his statement will reflect that the intercourse court was without consent. He said so in his report. He will say so. We believe and he must have it in his statements. Therefore, what evidence has been laid and what he has said in statement will contradict the charge. There are two things here. 377B talks about sexual intercourse against the order of nature. And there is no, which means it's consensual. 377B is consensual. 377C is non-consensual. So the charge has been framed under 377B. In other words, consensual. So if it is that, then we say the entire evidence will contradict the charge. It's not a question of lesser charge. You see, different ingredients are required for B and C.
What is B?
B is with consent, which means both parties can be charged. Either one can be charged. And the penalty is a maximum of 20 years. There is no minimum. But it is without consent under 377C. It's a minimum of 5 years and a maximum of 20 years.
So why would the prosecution want to charge it for 377?
I don't know. I mean, if at all, the charge ought to have been from the beginning with 377C.
What could be the reason for them?
I don't know. I don't know what the reason was. I mean, I don't know. It's not a question of discretion. I mean, you're not questioning the prosecutor's discretion to frame a charge. You can frame any charge. But if he frames a charge which is not supported by the evidence, then you say the charge must be struck out.
This could be a faulty charge, yeah? If it's a faulty charge, if the charge is not, I mean, what is the consequence?
As far as we are concerned, the consequences would be this, that Saiful is lying in court. He's saying it was without consent, but the AG has framed the charge, where it is with consent.
What could be the reason?
I don't know. I don't know what the reason was.
So,
If I told the charge ought to have been under 377C, I think that's what it ought to have been.
can we
And
amend
that
the
question of
charge?
amendment does not arise at this stage. I don't think it arises. It's gone too far. It's gone to the extent of even applying to impeach the credit of this witness. So we now can't go back. We can't go back. I think, as far as we are concerned, the application should be allowed, which should be supplied with the former statements made to the police under section 112, which will definitely support his report, in which he says it was without consent, and will support his evidence in court, which is without consent. But all this will contradict the charge, which says it is with consent.
It's too late to amend the charge.
It's too late. As far as we are concerned, it's too late.
So we have to throw out the case.
It has to be done in that manner. It has to be that result which is inevitable. It is in our view.
Does the need to impeach Saiful arise here?
The question will, yes, of course. I mean, once we are supplied with a copy of the statement,
We move to impeach.
yes, the question to impeach him. And in fact, if we are supplied the 112 statements, it will not be a question of impeaching him really, because the statement will support his evidence in court. If you look at it that way,
He didn't contradict himself.
that's right. But the whole evidence and the statement will contradict the charge. I think that is what it is. I'm sure the 112 statement will be in support of his statement, evidence in court and his report, where he says it was without consent. But that will contradict the charge. The charge says with consent.
So they can't amend the charge and
I
bring
don't
another
think so.
fresh charge?
No, the
And
question of
then
fresh charge does not arise. I think the question of double jeopardy here.
You won't charge him for under the same section anymore. You cannot
I don't
charge
think so, because it has gone too far. It has gone too far. The charge ought to have been the beginning itself 377C. I don't know why. The prosecutor thought that it should be 377B, which is entirely different from C.
But is there any other reason you asked for impeachment?
No, very simple, because we feel the charge under 377B must be with consent. That's what the prosecutor is saying. That we will prove the case by saying that there was consent, on both sides. What can we do? I mean, if they frame the charge in that manner, I mean, we have every right to sort of, on that score, ask that the entire prosecution be thrown out. I mean, the charge be thrown out.
Could it be because there was no sign of tear, no sign of injury, external injuries, and that's why it has to be Section 74? Could it be?
Maybe it has to be consensual. Then it is 377B. The evidence should be towards consensual sex. But it's not. It's towards the other section. I mean, the prosecutor is doing. I mean, they have a right to prosecute in any manner they like. But if they do in the manner they have done in this case, then they have to face the consequences.
So YB, berdasarkan ujar-ujar yang YB berikan pagi tadi, ada harapan tak untuk dapatkan dokumen tu esok?
Saya kan ada harapan pulang kepada hakim sekarang. Kami sudah buat pengujian dan ada berasas dalam pengujian itu untuk kami dibakalkan dengan statement yang direkodkan daripada Saiful oleh polis dalam penyiasatan. I know it sounds a little weird, but
you can't impeach him because it's a charge.
Exactly.
Right? This time,
the first time it has arisen in this manner. Normally, it is not a contradiction between the evidence you give and the charge. A contradiction between the evidence you give, in court and the statement you make to the police. Here it is entirely different. A different sort of position.
So it's only right for the High Court judge to decide whether to throw out the case, or?
Well, rightly he should throw out the case. I can't see how it can be otherwise. Of course, it's up to the judge to decide. I mean, it is the prerogative.
Can he still order the case continue with the cross-examination and refuse to say that?
No, he will say that all that does not arise because it's fundamental. See, the defect is fundamental, and therefore, sort of carrying on with the cross-examination and the trial is waste of time and exercise in fidelity. Okay, thank you. Thank you. Thank you.